like I told you, he's an entertainment law attorney, and he's been representing music producers for a little while now. And some really great information on how to protect yourselves, like I was saying before, putting your music online, whether it's, you're trying to sell a beat or you just want to put it on SoundCloud or YouTube. Just some things that you can do to think about to start to protect yourselves. There are some sharks out there, okay? So yeah, he's gonna do his presentation. He's gonna leave time at the end for questions, okay? And I don't know, you can kind of run it how you want to, Ty, if you want to let them ask while you're speaking, or if you want to let them wait till the end. But I'm gonna turn it over to Ty, and I'll just be in the back hanging out.
All right, thanks.
All right, thank you.
All right, thanks for that.
Yeah.
All right, so yes, my name is Tyiase Hasan. I am a general practitioner. Part of my practice is entertainment law. I'm admitted to practice at the Supreme Court of Illinois, as well as the United States District Court for the Northern District of Illinois. And I've been practicing in Cook County, Chicago area for about 9 years. So what I want to do today is impart on you a legal perspective on what you guys are doing as beat makers and producers. So right now you're in a class and you're learning from one of the best in the business on how to make beats, how to launch your career.
You guys heard that right?
Launch your career is the fundamentals of becoming a beat maker. But what you're also doing from a legal perspective is you're creating property, okay? So it's not property like real estate, like this building. It's not personal property like your clothes or your phone, but it's an intellectual property. So what's an intellectual property? Well, it's not anything that you can always see or touch, but it's something that has value and it's something that you can own. And it depends on what it is you're creating. So in this instance, what you guys are creating is art. And art is protected under the US copyright statute. And this type of art that you are creating is known as a sound recording. That's what the statute calls it, sound recording. So there's 4 exclusive rights that you have to your sound recording. The first is the right to reproduce. No one can make copies to your work other than you as the author. The second is the right to make changes to it. So if you want to remix your beats later, only you can do that. The third is the right to distribute it. So whether you're going to share it, go online, upload it, however you want to distribute your work, only you have the right to do that. And lastly is the right to perform. Now, what is a performance under the copyright statute? It's whenever the sound recording is transmitted as digital audio. So that's anytime you hear it in the airwaves, anytime you hear it playing out of a speaker, if you hear it on a radio station, if you're in a grocery store, you're in a restaurant, bar, studio, theme park, wherever you're at and you're hearing this, that's counting as a performance. And so that's a valuable right, and that actually reminds me of what John wants you guys to know as starting out as artists, is that there's PROs. Okay, these are publishing rights organizations. There's some major ones, such as ASCAP and BMI. You may have heard of those before. But these major these organizations, they're not-for-profit organizations. They have millions of songs in their databanks. And they get these songs because artists like you, they go out and they register with them. You can register with them online. And once your song is in their data bank, they go out and they license your work to these third-party establishments. And they collect royalties for you. So, for example, if your song or your work is performed or played, say 100,000 times, you're going to get a percentage of that. The going rate on royalties is about 9.1 cents per play. So if you do the math on that, that comes to about $9,000. So that's a good way to get yourself out here and start promoting yourself, self-promoting yourself, is with the help of these PROs who are not-for-profit organizations. So that means they keep just 10% of the royalties that they collect from you. Either BMI or ASCAP does charge a initial enrollment fee. I forget which one it is, but it's pretty small in comparison to what the value of the services they're providing. So you can also track the number of plays your song has through a website called SongView that's co-managed by both of these PROs. Now, in protecting your rights, these 4 exclusive rights that you have, the first thing you want to do, even before you register with the PRO, is to register your copyright with the Copyright Office. It's a fairly simple process. There's an online application. You just fill in the information that they're asking for you. Like, for example, they're going to ask you who's the claimant, who's the author. It may be different because sometimes you could be in a scenario where you're like in a work-for-hire scenario where you're creating the work, but as soon as it's finished, someone else is going to take the credit for it. They're going to perhaps pay you in advance, and then once it's done, it becomes their property. So those are some things to consider later on as you're going into contracts, if the deal is going to make sense for you. But when you're registering with the Copyright Office, you're going to get a certificate of registration. It takes 4.5 months to get this, so it's something you kind of want to start the process on, like once you complete your work. And there's 2 reasons why you want to do this. The first reason is that sometimes you'll be in a situation where the end buyer or the licensee is going to want proof that you are the actual owner of this beat, because no one wants to buy into liability. They want to have assurances sometimes that if they buy this beat, they can go out, use it, and have it performed in different places and not have someone else come back later and say, hey, that's my work. Because the copyright statute is a strict liability statute. That means even if you do all that you can to ensure that you're not infringing on someone's work, you still can be what's called an innocent infringer. That's when you bought a copyright from someone, because as a beat producer, you may borrow from other producers out there if you have an agreement like that. So if you're borrowing from another producer and you're buying a license to that, but it turns out it was never theirs to begin with, you might be seen as an innocent infringer, and you still might be on the hook for some minimal statutory damages, possibly $250. But on the other extreme end, people who are willfully infringing on work, people who are just going out, taking your work and putting their name on it and then palming it off as theirs, that's called a willful infringement. And there's maximum penalties for those type of people that do that. They can be disgorged of profits. There's a lot of cases, I'm sure you've heard in the news of like blurred lines, some other cases. I'm representing a producer, a local Chicago producer, who has an infringement case against French Montana for a similar scenario. My client uploaded his work to SoundClick, and about 7 months later, his work is being used in one of French's songs. And so, we're going through a litigation scenario with French and his team right now. So these are some things you want to consider when you're registering your copyright. Is that one, you want to have it registered so that you can do business with other artists or licensees. And then another thing too is that in order to enforce your rights, you're going to have to show proof of your registration. Because if you go to court and you don't have a certificate of registration, then your case can get tossed out of court. Now the judge may allow you some time, and I can give you a whole lot of time, but they give you some time to go back and get a copy of your registration, or at least apply for one. And if you put a rush order on it, it's going to cost a lot. It's going to cost a minimum of $750. When if you just register it and wait the normal process of 4.5 months, it's only $60. So those are just a couple of things I wanted to get us started with. So I'll just open the floor. If you guys have any questions about anything I said, or anything general about your rights and all that with being beat producers, just let me know. Yeah, go ahead.
A question about sampling.
Yes.
The laws against sampling and everything say if somebody uses a sample.